This is an extremely serious matter. People are entitled, obviously, to the greatest privacy with respect to their tax returns. To be honest, I know nothing more about this than what I read in the ProPublica piece, which I also read and was astonished.
That was Attorney General Merrick Garland at a Senate budget hearing yesterday, responding to the recent ProPublica report that revealed the tax returns of the wealthiest men in America. Joe, first of all, your thoughts on this?
Well, you obviously the big headline was that the richest people in America, the multi-billionaires, don't pay enough taxes. But then when you get past that, which is, of course, disturbing enough, but it's something that we've known about, and it's something that Congress obviously needs to make sure that Amazon and other multinational corporations pay more than $0 a year, and make sure that these billionaires pay at least as much of a high as a tax rate as janitors and clerical workers that work with them, for them. But Willie, how extraordinarily disturbing that people's tax returns, any American's tax returns, are seized, by whomever in the government and then leaked out there. There's a reason why it took years for prosecutors pursuing criminal charges against Donald Trump or civil charges against Donald Trump. There was a reason they had to go through the courts to get those tax records. Those records are supposed to be safe. But here, these people were specifically targeted. And I don't care what ideological point you're trying to make. And I probably agree with the ideological point that these people were trying to make. You don't get there by violating the most basic privacy rights of Americans.
Yeah, no one's going to weep for Jeff Bezos. And it started the conversation about why the richest people in the country don't pay any taxes. That's one issue and worthy of investigation. I think we all agree on that, as we said over the last couple of days. But the other side of that, as you point out, is ProPublica got, it says, 15 years worth, thousands of people's tax records, a trove of information. So today it's Elon Musk and Jeff Bezos and Mike Bloomberg, as you see there. But what's stopping whoever leaked this information from targeting somebody they just don't like? Maybe not the richest person in the world, somebody that they have a political difference with. The idea that you could leak that kind of private information is scary. Again, two separate thoughts. Rich people should pay taxes. Yes, we all agree on that. On the other side of it, everyone in this country is entitled to privacy around issues like taxes.
So Merrick Garland was also asked about the Justice Department's decision to continue defending Donald Trump in a defamation lawsuit connected to a decades-old rape allegation. Writer E. Jean Carroll sued Trump for defamation in 2019 after he denied her allegation of rape in the 1990s. Then, using the federal law that prevents government employees from being sued for defamation, the Trump Justice Department made itself the defendant in the case instead of Trump. A federal judge then blocked the move. But this week, the Biden Justice Department responded, essentially making the same argument as the previous administration. Here's what Attorney General Garland said yesterday about that decision.
Our job is to represent the American people. And our job in doing so is to ensure adherence to the rule of law. It is not always easy to apply that rule. Sometimes it means that we have to make a decision about the law that we would never have made and that we strongly disagree with as a matter of policy. But in every case, the job of the Justice Department is to make the best judgment it can as to what the law requires.
Joining us now, former U.S. Attorney for the Northern District of Alabama and an MSNBC legal analyst, Joyce Vance. Her latest piece is entitled, Garland's Trump Defamation Lawsuit Decision Might Be Legally Defensible. It is also wrong. So I guess two things can be true at the same time, Joyce. But why do you think that he went this way?
Well, Mika, first, it's important to say what this isn't. This is not Garland being Barr and contorting the law to protect a president. Instead, what's happened here is that Merrick Garland is so hyper-focused on restoring the traditions at DOJ, that's a good thing, that they made the wrong call in this case. The real issue is whether or not the former president's defamatory comments about E. Jean Carroll were made in the course of his official duties, within the scope, as you would have it, of his employment. A federal judge has already found that Trump is not an employee in the typical sense, which is a condition that's necessary for DOJ to intervene here. But even more than that, that these comments went far beyond the scope of his presidential duties. He could have answered a question about whether or not he knew Carroll without calling her a liar and saying she wasn't his type. And one of the statements made here was voluntary. It was a written statement that the president issued without responding to any questions. So Garland could have distinguished Trump's conduct and still defended the institution of the presidency. It feels like a misstep early on, just 90 days in to his time in office.
E. Jean Carroll has hit roadblocks every step of the way. Does she have any options left in her search, her quest for justice?
This case is sitting at the Second Circuit Court of Appeals right now. They'll have to decide whether they'll credit the opinion of the district judge, in which case Carroll's lawsuit can go forward, or whether they'll stick with DOJ's view here. But there's a factual situation that's pretty compelling. And typically in a case like this, this is called Westfall immunity. DOJ shows up and says the United States is going to take responsibility for the acts of its employee. It wants to be the defendant in this case. And that happens early, often within weeks or at least a month of the case starting. Here, though, Trump's private lawyers spent almost a year delaying the case, exhausting his remedies, and then it was only at the last moment, when Trump was about to have to comply with a discovery order that would have asked him to give up his DNA so it could be compared to a address that Carroll had kept in her possession for decades. It was only at that point that DOJ stepped in and said, no, really, the United States should be the defendant here. So the Second Circuit has compelling reasons to let this case go forward.
All right, Joyce Vance, thank you very much, and thanks for writing that piece.